colleges, muftis and judges. By the time of the establishment of the Ottoman Empire in the 14th century, Islamic law was fully formed, in both its substance and institutions, and it was perhaps this inheritance of law that, by imposing legal and religious norms, did more than anything else to determine the future shape of Ottoman society. The Turks who, in the 14th century, made up the Muslim population of the Ottoman realms and of other Western Anatolian principalities, were largely illiterate and ignorant of all but the rudiments of their faith. What they knew they seemed to have acquired from their forebears' contact with Persian-speaking Muslims in Iran and Seljuk Anatolia. The basic religious vocabulary of Turkish remains, to this day, Persian in origin. It is, however, clear from inscriptions on their buildings, and from translations and adaptations which they commissioned of Arabic and Persian works 13 that the 14th century rulers of Western Anatolia rapidly adopted the cultural and literary forms of the old Islamic world. They also adopted Islamic law, specifically the law of the Hanafi school, which had been current in Anatolia under the Seljuks and which, under the aegis of the Ottoman sultans, was to become the dominant school of Islamic law in the Middle East. To establish a legal system, however, demanded the foundation of colleges to train the professors, muftis, and judges that were essential to its operation. The chronicler Ashik Pashazaide credits Orhan, circa 1324-62, with a foundation in Iznik of the First Ottoman College. He adds that he appointed Davud of Kayseri as the first professor of Davud. The 16th century scholar Shaikh-ul-Islams writes, he studied in his own land, and then journeyed to Cairo, to study Quranic exegesis, traditions of the Prophet, and the principles of jurisprudence. Under its scholars, he distinguished himself in the rational sciences and acquired the science of mysticism. Sultan Orhan built a college in the city of Iznik. From what I have heard from reliable sources, this was the first college to be built in the Ottoman realms, and he appointed Davud of Kayseri to its professorship. Given the time lapse between the events described and the sources, it is not clear whether these stories are, in all respects, accurate. They are, however, plausible in detail and certainly accurate in a general sense. In the first half-century of the empire's existence, there was no tradition of Islamic learning in Ottoman territory. It was necessary, therefore, to import teachers to staff the new colleges. The tradition makes Davud a native of Kayseri, where he had also studied. This central Anatolian city had become a center of learning and culture during the Seljuk era, and Davud's transfer to Iznik was therefore an example of how the Ottoman and other West Anatolian rulers transplanted the culture of the old Muslim world to the newly conquered territories in the West. It is significant, too, that Shaikh-ul-Islams should mention Davud's journey to Cairo to pursue his studies. Although Kayseri had been a Muslim city since the Seljuk conquest and settlement in the late 11th and 12th centuries, as a center of learning it was insignificant in comparison with the great cities of the Muslim Old World, such as Damascus or Cairo. For scholars from Anatolia, learning journeys to these cities were part of their education. Davud of Kayseri's successor but one at the college in Iznik was Molla Aladdin, known as Kara Oha, who, according to Shaikh-ul-Islams, went to the land of Persia and studied with its scholars before his return to Anatolia and appointment to Iznik. One of Molla Aladdin's pupils was Molla Shamsuddin Fenari, 1350-1431, whom Shaikh-ul-Islams reports as becoming professor in Bursa at the monastery college, and judge there, as well as mufti in the Ottoman realms and Abbas. Fenari, too, after his study at Iznik, had traveled to Cairo to complete his education. So, too, did the jurist and mystic, Sheikh Bedruddin, who was to lead the rebellion against Mehmed I, 1413-21. In 1416.14 some Anatolian scholars settled in the cities where they had studied, and made their careers there. An example in the first half of the 15th century is the jurist Ibn Humam, d. 1457, a native of the Anatolian city of Shivas. 15. These journeys to the centers of learning in the old Muslim world were clearly essential to the transfer of Muslim law and culture to the early Ottoman Empire. Eventually, with the endowment of new colleges by the sultans and their wealthy followers, and with the annexation by conquest of the pre-Ottoman colleges in Anatolia, the Ottoman Empire itself had, by 1500, become an important center of learning. Although journeys in quest of knowledge remained a feature of Muslim scholarly life, they were no longer a requirement for Ottoman students. Indeed, the prospects of sultanic patronage began to draw scholars from outside the empire to the Ottoman capital. 16. Furthermore, the conquest of Syria and Egypt in 1516-17 brought the old centers of learning in Damascus and Cairo into the Sultan's realms. By the second half of the 15th century and, especially, during the 16th and 17th, It was scholars working in the Ottoman realm such as Molla Huzrev, d. 1480, Ibrahim of Aleppo, d. 1549, Ibn Nujaym, d. 1563, or Tamirtashi, d. 1595, who were producing the most highly regarded manuals of Hanafi law. It was the system of colleges within the empire that supported this growth in scholarly activity, as well as training new generations of teachers and muftis, and staffing the law courts with judges. Each college in the empire was an independent foundation, with its own endowment, trustees and administrator. Nevertheless, by the first half of the 16th century, a hierarchy of colleges had developed, with the salaries paid to professors and, to some degree, the books taught, determining a college's place within it. At the lowest level were those that paid their professor 20 akshas daily. At the top, from the 1470s, were the 8 colleges which Mehmed II, 1451–81, had established around his mosque in Istanbul. After Suleiman I, 1520–66, had completed the construction of the Soleimaniye in 1557, the colleges attached to this mosque came to occupy a position equal to the 8 colleges of Mehmed II. With the elaboration of this hierarchy, the Sultan sought to control the progression of students and teachers through the colleges. The so-called Law Book of Mehmed II, in this section perhaps dating from the early 16th century, lays out, in a highly idealized form, how a teaching career should progress. On graduating, a student should become a candidate for office, and then receive a professorship at 20 akshas per day. He should then progress through the college system in steps of 5 akshas, moving to a college paying 25 akshas a day, then to a 30 aksh college, and so on until he reached one of the 8 colleges. This could be the first step to appointment as a judge in a large city, earning 500 akshas a day. From this position it was possible to become a military judge sitting on the imperial council. The systematization of the colleges also brought attempts to control the progress of students. A law book of scholars, undated but presumably from the first half of the 16th century, tries in particular to ensure that students should continue to study the respected books according to the old custom, and not to aim for quick promotion by petitioning an apos. Instead, each student, on completing a course with a professor, should obtain a certificate stating how much of each book he had read, and the professor at the next grade should not accept him without examining this certificate. The law book also creates a rudimentary syllabus, by naming, in abbreviated form, the titles of the books which a student should study at each grade. In particular, professors at each stage should teach texts and commentaries on jurisprudence. The law book concludes with a statement that any professor or student not observing these regulations should suffer a severe punishment. A second law book, which apparently went to the inner colleges of the empire, that is, those in Istanbul and the old capitals of Bursa and Edirne, reiterates these rules, after a preamble, where the Sultan states that it has been heard that teaching and learning are in decay, that the banners of science are broken, and the college is empty of teaching and learning. The law book again insists that no student should begin a book until he has fully mastered the one which preceded it in the syllabus. Only when they have properly studied all the books at a particular level should they receive a certificate from the professor, permitting them to proceed to the next grade. In particular, the law book states, students have been reaching the highest grade in the 8 colleges in a year, or even less. In future, students should read all the books required at each level and reach the 8 colleges in no less than 5 years. The law book concludes by stating that the colleges would be under surveillance, and that any professor who disobeyed the command would suffer dismissal. At the turn of the 17th century, a decree of Mehmed III, 1595–1606, repeated these edicts. 17. Although they were nominally independent, the colleges came, during the 16th century, to form something approaching an imperial system, with appointments and syllabuses under the control of the Sultan. They were, in fact, a vital element in Ottoman government, most obviously because they provided the legal training necessary for judges. They also provided career opportunities for native Muslims, mostly Turks in Anatolia and Rumelia, mostly Arabs in Syria, Egypt and Iraq, who found themselves excluded from the palace schools, and so from careers as provincial governors and viziers. By the 16th century, a graduate of a college had a choice of 3 careers in particular. He could, with the right connections, join the scribal service, in the Sultan's government or in a great household. Otherwise, he had the choice of a teaching career or a career as judge. In either case, he required, as a first step, the sponsorship of a senior member of the learned profession, who could nominate him as a candidate for office in attendance, nominally on the Sultan, but, in practice, on one of the military judges who actually made the appointments. If a student came from one of the learned families that emerged during the 16th century and came to monopolize the higher offices in the learned profession, he could gain the sponsorship of a well-positioned relative. Otherwise, he could seek the support of his teacher or other member of the profession, sometimes by providing a service, such as teaching assistant in a college or clerk in the office of a military judge. 18. Until the 1530s, the system of sponsoring candidates was clearly haphazard. However, during his period as military judge of Roumellia, between 1537 and 1545, the most renowned of Ottoman legal figures, Abu Su'o, circa 1490 to 1574, reformed the system, following complaints from graduates that the military judge of Anatolia, Shivazade Mahieddin, was preventing their enrollment as candidates for office. Henceforward, military judges were to keep special registers for enrolling candidates, while holders of high office had the right to nominate candidates at intervals of 7 years. At the same time, Abu Su'o fixed the number of candidates that holders of specified offices might nominate at 10 each for military judges, 5 each for the judges of Istanbul, Edirne, and Bursa, and 3 each for the judges of other important cities. In practice, the nomination of candidates seems to have happened at intervals of less than 7 years, and it was customary for the sultans to decree ceremonial investitures on great occasions of state, or to honor the appointment of a new military judge or chief mufti. Nonetheless, the measures which Abu Su'o introduced had the effect of controlling the intake of candidates into the learned professions and presumably of preventing the holders of the highest offices from monopolizing the nomination of candidates. 19. If a candidate chose to follow a career as teacher, he could expect an initial appointment in a provincial college with a low stipend. From here he could advance, with occasional periods out of office, through the hierarchy of colleges. The most successful could arrive, eventually, at one of the 8 colleges or, after their completion in 1557, at one of the colleges of the Sulaymaniyeh. It was above all a scholar's place in a particular college and the level of his stipend that determined his standing in the learned profession. This becomes clear from the collection of biographies by Nevzat Atayi, 1583 to 1636, of scholars active between the reigns of Suleiman I, 1520 to 66, and Murad IV, 1623-40. Atayi's biographies are usually little more than a record of what colleges each scholar had taught at, and what other offices he had held. For example, in his account of a certain Mullah Mahmud, who flourished during the reign of Ahmed I, 1603-17, he tells us only that the royal tutor, historian and chief mufti, Sad ad-Din, had sponsored him for office, and that after he had reached the grade of a 40 college, the lowest grade which Atayi considers worth recording, in 1605 he became professor at the Ibrahim Pasha College, and then, in 1608, at the Shinan Pasha College. In 1611, he moved to Edirne, where he died in the following year. For the more distinguished figures, Atayi also gives anecdotes and perhaps also a list of their writings. Nonetheless, it is always progression through the hierarchy of colleges and offices that provides the outline of his account, indicating how firmly established the career structure in the learned profession had become. A career as a judge followed a pattern similar to that of a college teacher. It is possible that, up until the first half of the 15th century, Sanjak governors and other local authorities could appoint and promote judges. Certainly the 1431 cadastral survey of southern Albania shows that the Sanjak governor granted an addition to the fief of the judge of Kanina in accordance with the letter of the governor, Zaganos Bey and Apas. By the 16th century, however, an aspiring judge had first to seek the recommendation of a senior member of the learned hierarchy to become a candidate in attendance on one of the military judges in Istanbul. An appointment as judge or deputy judge in one of the small towns of the empire followed. 20. In the early stages of their career, judges could earn more than professors in the colleges at an equivalent level. The lowest nominal salary that a judge received, whether paid in cash or held as a fief, was 25 akshas per day, as against 20 akshas for a novice teacher. In addition, he would receive fees and other emoluments. In another respect, however, the career had limitations. If a candidate chose initially to serve as a judge, rather than as a professor in a college, he would serve throughout his career in small towns and could never, as a rule, rise to become judge of a city. These positions, the great mollahships, were the preserve of men who had risen through the colleges, usually to become professor at the 8 colleges or at the Sulaymaniyeh. An example of this is the career of Abu Su'o, whose first teaching appointment, in 1517, was to the 30 College at 4 Nagel. By 1525, He was at the Sultaniyya College in Bursa, a foundation of Mehmed I, and, 2 years later, at one of the 8 colleges. In 1533, Suleiman I appointed him judge of Istanbul, effectively the senior judgeship in the empire, and then, in 1537, military judge of Rumelia. A candidate, therefore, who set out on a career as judge would find that, at the highest level, his path was blocked and he could never rise to become judge of Istanbul, Bursa, or Edirne, or of Cairo, Damascus, or Baghdad. This career limitation did not, however, apply only to judges. Increasingly during the 16th century and more markedly during the 17th and 18th, 22 the highest judicial positions became the preserve of a few elite families, and a college professor from outside this circle had no more chance of a malaship than did a small-town judge. It was presumably, therefore, to compensate frustrated aspirants to high positions that, during the late 16th century, it became possible, by enlarging the area of the court's jurisdiction, to designate minor judgeships as malaships. Some of the new malaships became permanent. Others were ad hominem. Atai records the career of a certain Molla Shinan, which provides an example. He had become a candidate for office after serving as a memorandum writer to the military judge, Abdurrahman, d. 1575, and then began a career as judge, serving in glorious towns, such as Tyre and Alas, Air and Apos. Then, through marriage, he became the protégé of a certain Ramazan Pasha, through whom he acquired a post as financial inspector and, with it, the opportunity to accumulate wealth. In view of his new position, he began to regard a small-town judgeship as too humble and to seek a malaship. To this end, he attached himself to the following of the Grand Vizier, Ibrahim Pasha, commander of the army in Hungary. This must have been in 1599 to 1601. The vizier, on his behalf, secured the elevation of the judgeship of Tyre, a small town in western Anatolia, to a malaship, and its bestowal, in 1601, on Molla Shinan. The malaships of the great cities, however, which secured access to higher office, remained the monopoly of the elite. The judges were perhaps the most important figures in the day-to-day administration of the Ottoman Empire. Every city, town, village, and settlement within the empire came under the authority of a judge, and every individual within the judicial district, whatever his or her religion, had the right of recourse to the judge's court. Furthermore, the absence of lawyers and the fact that the public seem to have had access to the judge or his deputy at all hours, ensured that the courts dealt with business very quickly. 23. The functions of the judge were also very wide. In the first place, he presided over his court, administering, in most parts of the empire, Hanafi law, no matter what the religion or legal school of the parties concerned. His court was open to anyone who wished to bring a lawsuit or make a claim. Ottoman judges also acted as notaries, ensuring the observance of the proper legal forms and providing written records of acts such as, for example, marriage, divorce, the sale and purchase of real estate, or the foundation of trusts. A few entries from the Register of the Court of Ankara for 2 days in January 1583 give an impression of a judge's daily routine. A man demands the return of goods given as a pledge. Another seeks compensation from a man who has killed his pack horse. The manager of a trust demands 10 gold coins owing to him. The judge records that a village has paid 340 akshas in lieu of barley to the agent who had come to collect barley for the sultan's camels. A man records that he is no longer marrying his fiancée and that the parties had returned all goods exchanged in prenuptial arrangements. A man stands surety for another in a transaction concerning a horse, claiming that her husband has divorced her. A woman demands that he pay her dower and also the maintenance due for the period during which she may not legally remarry. A villager complains about another who plays a musical instrument.